Hello, my name is Martin Lijtmaer. I'm a criminal and immigration lawyer here in Los Angeles, California. One of my areas of specialty is dealing with past criminal convictions for non citizens. So, in other words, if someone had, for example, a drug offense dating back to 1995, um, that person would likely be ineligible for any immigration benefit and would be deportable if they were not a U.S. citizen. So, what I do for these clients that come to me is I try to reopen their old criminal case and vacate, in other words, clear their old conviction, and then resolve the case in a way that it won't affect them from an immigration perspective, or give them the opportunity to avoid deportation, or even the opportunity to become a resident or a citizen of the United States. So there's a process in California called an expungement. And unfortunately, an expungement is not a good word because it doesn't really tell you what an expungement does. An expungement is merely a dismissal after the fact. And a lot of people think that by expunging, and I put that in quotes because it doesn't really mean to expunge as one would think the dictionary definition has it. People think that if you expunge an old conviction, that they should be okay for their immigration status, or that the immigration court would stop deportation proceedings because they expunged that record. The reality is, immigration courts and immigration law does not recognize expungements as, in a California expungement specifically, as a way to clear a criminal conviction. So even if that person with that drug conviction from the 90s expunged that conviction, they would still be deportable and subject to all the issues and problems that a conviction would otherwise have. So there's a different process that we have to take in California, and that is via a motion, which is codified in Penal Code 1473.7. That law allows certain defendants who qualify to vacate or clear an old conviction if certain circumstances can be established. Those two circumstances are one, that the person did not have a meaningful understanding of the immigration consequences at the time they accepted a plea deal. And notice I say plea deal because this law right now applies to people who accepted a plea deal as opposed to going to trial. So, part one, the defendant has to establish that they did not have a full understanding of the immigration consequences when they took the deal. And part two, that they suffered prejudice, it's a legal term, such that they would not have accepted that deal had they known at the time that it would have such drastic immigration consequences. The law is new, came out several years ago, and it's still being developed in the courts. But right now, I have done over 20 or 30 of these in the past couple years, and I'm well versed in the law. If you feel like you might benefit from vacating a conviction from the past, and again, this is for immigration consequences, give me a call. My number is 323-379-5458. Or you could just click on my website at www.litlaw.com. And I look forward to hearing from you. Thank you.